Hello, folks. Time to get through what happened in the Sherrone Moore case. When we left off Friday, they went to lunch. And then, both me and Mo had other things to do. But it was settled in the afternoon. There's a few things here I want to go through with you guys that I am a bit disappointed about. So let's go through this and I will tell you why.
You may be seated. Court does call the case of the people of the state of Michigan versus Sherrone Moore.
Good afternoon, Your Honor. Katie Rosmerski for the people.
Good afternoon, Your Honor. Ellen Michaels on behalf of Sherrone Moore, who's present in court. State your name.
Sherrone Moore. Thank you.
Christine Jacobs on behalf of Sherrone Moore.
All right, thank you. You may be seated. All right. So date and time set for Frank's hearing, things have changed. And even before you go on, I just want to express the court's appreciation for the hard work of counsel going through. I know it may have been a delay for the people that were waiting to see something, but your efforts were greatly appreciated. Mr. Smirsky.
Your Honor, thank you, and I appreciate the opportunity to address the court.
Yeah, as we found out, they were about to have an evidentiary hearing, a Frank's hearing. As you might recall, Judge Simpson was more than annoyed that the state and especially the charging officer, the charging investigator, omitted a whole lot of information to the magistrate court, to the magistrate judge, which got Mr. Moore arrested. So I was actually looking forward to that Frank's hearing to hear this cop who decided, you know what, I'm not going to outright lie to the court, but I'm going to omit as much as humanly possible to make it seem as bad as possible for Mr. Moore.
First, allow me to apologize to the court and counsel. I was needed unexpectedly elsewhere in another county on a special prosecutor case this morning that went perhaps a little bit longer than expected, and then as life unfolds, I was rear-ended in a gas station parking lot. Everybody is fine, but I really appreciate everyone's patience, and it was not intentional. Thank you.
Okay, so the reports from court that morning was that, or just before lunch, was that they were having discussion in chamber. But as it seems, the prosecutor was late because of reasons.
Judge, I appreciate the opportunity to address the court about what has transpired and where we have arrived. This case, as is true with many cases, Your Honor, is alive and sort of moving and breathing. Investigation has been ongoing. An exchange of information has also been ongoing. As a result of all of that, where we have arrived, based on what we now know, is that we feel the most appropriate charges to address the defendant's behavior on December 10th of 2025 are two additional counts 4 and 5. We would be seeking to add a count of what we call malicious use of a telecommunications device in the
Malicious use of a telecommunication device is he was very rude on texts. Now, apparently, the text he sent after he went to the alleged victim was way beyond what you would expect. So, but this is still a misdemeanor.
Context of a domestic relationship, and then an additional count of trespass.
Yeah, and trespassing, which is you're not allowed to be here. And usually, when we see this out in the wild, cops show up and tell them, go away. On extreme cases, they might, if people don't want to leave, the cops make an appropriate report. So these two additional, at the moment, as she puts it, are a tad more than is acceptable. A tad more than is acceptable.
Those are, as Your Honor is aware, misdemeanor matters. Your Honor, we have arrived at that as indicated based on a thorough review of the additional evolved evidence and investigation, as well as after consultation with, pursuant to our obligation of the Crime Victim Rights Act, consultation with the victim, largely through her representatives in this matter. Your Honor, one comment I would like to make specifically about the additional count of malicious use of a telecommunications device in the context of a domestic relationship. As this court is aware.
Yeah. In context of a domestic relationship. This is the information the charging officer did not tell the magistrate judge. The magistrate judge was under the impression that with this, basically, a stranger showed up at her house, a stalker. I mean, really serious stuff. But this seems to be what actually happened. They had a relationship. The relationship ended. There were nasty words. He showed up at her place and then left. That's it.
I would like to be clear for the record because of, I know, docket and calendaring purposes. Your Honor, we did not at the time of issuing initial charges in this matter, nor do we believe now, after additional evidence has been presented to us, do not believe that there is sufficient evidence to prove a count of domestic violence in this matter.
There were never, not even before the magistrate judge, there were never a charge of domestic violence. Never. There was a 911 call, allegedly by the alleged victim's attorney, that spoke of domestic violence. That, in my opinion, was her representative lying in a 911 call to get cops there faster. My guess is nothing will happen with that false reporting.
Historically, and not what happened on December 10th. So we are obligated, as this court is well aware, legally and ethically and morally to not charge that which we do not think we can prove. What we do believe the evidence supports is criminal misbehavior in the context of an intimate partner relationship, and that is why that tag-on is on the malicious use charge. Your Honor, it is my understanding that pursuant to adding those counts, that there will be a plea.
They were based, what the prosecution is saying, they had a huge argument. And now Mr. Moore has a criminal record.
Result of that, but I leave that to counsel.
Did you want to say something?
Yes, thank you so much. I'd like the record to be clear that the negotiated disposition involves a dismissal of the 3 charges that had been charged. That was not mentioned in the recitation by the prosecutor's office.
That is absolutely correct. The end result of where we land by adding on the counts is that my best understanding is that the defendant will enter a plea to those additional counts, and in exchange for that, we will absolutely dismiss the originally charged 3 counts. Thank you.
Yeah. So the original 3 counts in this case was, let's see here, what was it? The original 3 counts was home invasion, stalking, breaking and entering. It seems like, as the prosecution said, in context of the information they now know, yeah, it was never that severe. Never that severe. But Mr. Moore is pleading to these two lesser charges. One of them can be 6 months in jail. The other up to 30 days. Mr. Moore has no criminal record, so my belief here is that he will get probation and a stay-away order. But that's in the probation from the alleged victim. What I'm very, very disappointed in here is the person who got away scot-free, the charging investigator, who all but outright lied to the magistrate court about what happened. I was looking forward of having that charging officer on the stand explaining themselves. I would love to have the alleged victim's representative who made the 911 call be on the stand and explain why they lied in the 911 call. But that now will not happen. Well, if this representative is also an attorney, they failed their responsibility of candor to the court, of making false statements to the police, and they will probably get away with it. This seems to be a heated argument between two people who broke up. Now, there are more to it, of course. Sherrone Moore, I cannot say this strongly enough. After almost 35 years in labor and employment law, do not stick your pecker in your direct subordinate. Don't. If you're married, even more don't. Nothing good would ever come out of it. As you can see here, where a heated argument ended up in him now having a criminal record. Was it worth it, Mr. Moore, sticking your pecker in her? No. So this, I hope, can go as a warning. If you are a boss somewhere, you hire somebody, you're an assistant, a secretary, whatever's, and you're also married, don't. It will not end well for anyone. But that, now the sentencing is April 13th or 14th, I believe. But for me, this will end my coverage of former head coach Sherrone Moore and this case with some disappointment, because everything in this case was avoidable. He should not have stuck his pecker in his direct subordinate. He should not have ended her contract. Because stupid. She will retaliate. And you lost your multi-million dollar a year head coach job. You will probably never be a head coach. You're lucky if you be a coach in in high school somewhere. You could have had it all, a legacy, millions, and you threw it all away because you just had to put your pecker into your direct subordinate. Thank you for listening in. You all have a good one, and I will see you in the next stream or video. Bye-bye.